Okay, so welcome to part two of Wanda Busby and Homer Busby versus George Arnold. Again, just to kind of give a brief synopsis, this is a complaint for automobile negligence where plaintiff Wanda and Homer Busby are suing George Arnold for negligence and damages. So again, we're still here. So just to kind of give you just a little bit of what it looks like again. So it shows the jurisdiction and venue, which again where it's filed as in circuit court. I'm sorry if I didn't say that again, and it is jury demanded. So, and the jurisdiction and venue, Shelby County, Tennessee, so Memphis, Tennessee. That was the easiest to actually do, and especially since I've done this years ago. So I'm glad I kept this information just for my own records um, and again, these are just the facts of the case as far as what happened and why she's suing him and even the eyewitness testimony and everything that we discussed. We did go through the timeline of just pretty much of her starting her pleading. And if you kind of want to know what a pleading is, I don't know if you all already read that. It's pretty much just a formal or written allegation filed by the court, and it's usually by both sides to a lawsuit. So if you want to know where that is, it's actually in chapter 2, page 24 of our book. Pretty much, it's actually 2-6, identifying the legal issues in your client's case. So if you haven't read, then that's kind of where it is. And it just gives you actually a formal definition. So the formal written allegations filed with the court by both sides to a lawsuit. Claims and defenses are clearly set out so that both parties are placed on notice of the position of the opposing party. So again, we've already gone over all of that, and as you can see, I showed you in the first segment the a deposition, answers the complaint, the answer to the complaint, and so on and so forth. So you got a chance to see that, and you don't have to see that again if you don't want to, but that's where that came from. But what I wanted to do in the part two is well, let's just say this. I want to say that based on the evidence in the complaint, hypothetically, we're going to say that since it is jury demanded, that the jury ruled in favor of Wanda and Homer Busby for their complaint for automobile negligence. Because as I mentioned before, one thing that stood out about the defendant, George Arnold's testimony, was that he stopped, but he was actually under the light, but he was for certain that it was green. So in a way, one of the things that she mentioned in her case was that she felt that he was pretty much negligent, because if you look back at the elements again on chapter 2, page 26 under 2.7, writing issue statements, it's pretty much it hit all marks or all buttons on the 4 elements. So a duty to on the part of the defendant to act in a safe manner. So as far as being safe, he put his brakes on, but he was still under the light. So there's no way to truly tell if the light was green or if it was red, because by his own admission, he was under it. And breach of duty to behave in a safe manner, just him being over the line, that actually is not safe, because those lines are there for a reason, for you to prevent an accident. So in the event that like he mentioned earlier, that he heard her gun his motor, gun her motor, I'm sorry, if that's something like that should happen, then it's safe for her to go ahead and go without causing damages. So he had the ability, I would say, to mitigate his own damages. So with that being said, and as far as causation, when it comes to injuries, they both sustained injuries and damage, but in a way it was by his own fault, that he could have prevented if he was to stay behind the line where he can truly see the light, and it's true and accurate. So I'll say that's just kind of in his as far as going against him when it comes to establishing a prima facie case. So she had a strong case. So that's why um, the judge and jury ruled in favor of Wanda and Homer Busby. So let's say if we flip it, and let's say George, as I mentioned before, in the facts of the case, that he also sustained injuries. Now there was several witnesses to the incident or to the accident as well, and among them was Fred Green. Now, with Fred Green, again, he recalled that he applied his own brakes, and as he approached the intersection, he recalled the other drivers heading in the same direction. Um, and also, Green stopped at the intersection and observed the defendant George Arnold drive through the intersection, striking the plaintiff's vehicle on the passenger side. Um, so, with that being said, and again, both parties suffered injuries and had to go to the hospital, and damages to both vehicles. Um, what I would say is that George Arnold feels like he too has suffered, so therefore he should not be the one to have to pay for everything, or to be the one that's charged with negligence. He feels that it actually is in fact Mrs. Busby, because she's the one that's injured, for one thing, or she's the one that could have waited because he heard her gun, her motor, and that she failed to maintain a safe lookout. I would say that. So within his in his appeal, he is wanting the case to be retried. Now, I would say that's kind of like the IRAC method. So we've given you the statement of facts of the case where they both had an accident at an intersection, and they both sustained injuries. Um, Mrs. Or the plaintiff, Wanda, filed a claim or filed a pleading against um, Mr. or the defendant, um, for negligence for an automobile, and pretty much the issue it was that whether or not he is actually the proximate cause of or I would just say, well, I want to read it here, direct and proximate cause of the accident of negligence. So that's the issue. And the rule of law would say is that it was found that he was actually um, approximate cause because, again, um, the four elements of her case, every button was hit. So he, being under the light, or under, didn't truly know based on his own testimony. He kind of sunk his own testimony. So that's just what that is. When we apply the analysis or the application of the law, it's pretty much what it is that he did not um, that he pretty much sunk his own testimony. So by saying that he wasn't really clear, so that little room for uncertainty or that reasonable doubt. So I would say that I would say more likely than not, that he would be the one to be responsible because of the fact that not only was he under over the line, the legal line or the safety line, he was over, he was under the light, so he couldn't really say for certain what color his light was, even though he heard her gun, her motor. But at the same time, it's all about safety, and he had the ability to, I would say, mitigate his own damages by maintaining that behind that safety line. That's what he should have done. He did not. In conclusion, jury and judge ruled against the defendant and ruled in favor of Wanda and Homer Busby. So that's the IRAC method for you if you just kind of want to know how that flows. But that's just pretty much what happened. Now the appeals process is a little bit different. And again, we're using Tennessee courts, so it's actually the Tennessee Court of Appeals. One thing about the Tennessee Court of Appeals, I did want to let you all know kind of where I went to, and I'll show you here as well. It's actually Tennessee courts, which was the easiest. Let me go back here into Chrome. You can actually, and if you, into one rule of thumb, if you want to know like what court goes next and after the other, let me just show you. That may be easier. if we go here and just click on courts, and it just brings up all the courts, it's actually showing you highest to lowest anyway. So obviously from here, these are the state courts, and then this is just the appellate court's office, a clerk's office. So that's just like a little thumbtack there, but it goes right up to Court of Appeals here. And then from, oh, this is criminal court, I'm sorry. We're going to actually go to just regular Court of Appeals, since it's not criminal, it's just a civil matter. So civil here. When you go under the civil courts, you can just click on Learn More here. It gives you a list of all the judges that sit, which is about 12 judges there, and you can see their picture there. But one of the questions that was asked is if do appellate courts retry the case, and what do appellate courts do? What might be the basis of the appeal? Um, and pretty much with his, let's say, um, again, we're going to file it. It's a civil case, so we're filing it with the Tennessee Court of Appeals. I just wanted to kind of look back at my notes here. I wanted to be for certain. And then what's the basis of the appeal? So the basis of the appeal is that pretty much he didn't like the decision. He felt like it should have gone in his favor. He too sustained injuries. George Arnold, the defendant, he too sustained injuries, lost quality of life. I'm pretty sure because in the facts, he was coming home from work, so that appears to be his work truck as well. That he was utilizing when the whole situation happened, and so that quality of life and loss of income. If he wants to file for that and appeal and sue for that, he can to appeal the original decision of the circuit court. So that is something that he can do. Do appellate courts retry the case? Well, let's see here. I think we have it here, and I believe they do, but let's just read it. All decisions made by Court of Appeals may be appealed. So there's your answer: by permission to the Tennessee Supreme Court. As in all three appellate courts, Court of Appeals hearings do not include witnesses, juries, or testimonies. Instead, attorneys may present oral and written arguments. Judges of the Court of Appeals are elected on a retained replacement. Okay, so that's just something else. We don't want to read that. But yeah, so that's pretty much the answer to your question. So it looks like they can. It doesn't have to require a jury decision or anything like that. It's just the judges that are there. They're going to hear the facts again, and if it turns out everything is okay, then they'll make their own decision and say, and they'll overturn the decision of the circuit court. But in this fact pattern, I'm going to say that they agree with the decision of the circuit court, because, to be honest, it goes back to those elements of law and elements as to what truly happened, and his own testimony pretty much again sunk him again. Now, and he had the ability still to mitigate his own damages, so he did not. And which was pretty much a approximate cause. Now, not to say that she wasn't in the wrong because she too did fail to maintain a self lookout, but technically she had the right of way, because if he that little bit of technicality is sometimes it's a little bit that takes the whole thing to another level. So that thing that you don't think about, that you say or that you do, be the very thing that will either hurt or help you. So in his case, it hurt him. So I'm going to say and assume that that the Court of Appeals agrees with the decision of the circuit court, and that he appealed again to the next court, which actually is, again, like I said, it shows you an order here. So that goes to the Supreme Court. Now, with the Supreme Court, this is the final decision. So it's like this is for all the morals. Now, if they choose to hear new evidence, they will. They don't have to. It's usually up to them. Let me just kind of get that information here. Because keep in mind, he did have some affirmative defenses. Now, if you want to kind of know what affirmative defenses are, I want to go back to that in my book here on my notes. So, because he did have that. Let's see here. I think that was chapter 1. I was actually just looking at it. I'm sorry. Let me go back. Affirmative defenses. And yeah, that was page 24. I don't know why I went so far back. That was actually still on chapter 2, page 24. Affirmative defenses, defenses raised by the defendant in the answer, reasons why the plaintiff should not recover, even if all of the allegations of the complaint are true. So again, because he felt that she was also wrong in the situation, is where she gunned her motor and she kept going and didn't stop and didn't. She failed to maintain a safe lookout. Um, just those city ordinances that she violated and he feels like she's in violation of. He also feels that she should pay for his injuries because he had to go to the hospital too because of what we just mentioned, just failure to maintain a safe lookout. So in his defense, or like I said, affirmative defenses, that there, he feels that she was actually the one that was negligent, or at least half and half. Where I would believe that if it were me, I would think that we would both be equally responsible as far as when it comes to uh, causes of action. So causation and who did what, that we would be equally responsible for equal damages. So I would assume if it was me, if that was the case. But again, that small little technicality is what will sink him. So um, as we get back into the Supreme Court, let me go back there. I'm gonna look back at my notes again. All right, and let's see here. So we have here the Supreme Court. That just talks about where they normally meet. Yeah, so that's what I said. The state court's last resort. That's why I said this is for all the marbles. So I mentioned that. Let's see. So it's both civil and criminal. So this is a civil matter, so we're in the right place. Um, and they also interpret the laws and constitutions of Tennessee and the United States. So yeah, so they just pretty much help you understand why the law is what it is, and why what happened. Again, even though he is appealing to them, still, again, if you have the ability to mitigate your own damages, do it. Don't wait until, you know, somebody else makes a decision for you that you could have made for yourself, in that moment. So it's just a little uh, it's something that you have to know and do within yourself. And you have to help yourself sometimes. So that's just pretty much what that is. And that's why he's exhausting all of his resources and appealing the decision of the lower courts because of that. Let's see here. The Supreme Court may assume jurisdiction over undecided cases in the Court of Appeals or criminal courts, and there is special need for expedited decision. So there's not a need here for really an expedited decision. And the reason why I say that is because nobody's on death row. It's not, time is of the essence when it comes to a child being adopted somewhere, and if they don't adopt it in a certain window of time, they'll lose the ability to do so. No, nobody's in a hurry. So right now, everybody's just mad. You hit my car. No, you hit my car. You sustain damages and I sustain damages. I shouldn't have to pay for all of yours as what was mine too. You should pay for something. So that's just pretty much what it is. When you have an argument and you need somebody, a mediator, to kind of help you make your decision and move you along. So no expedited decisions are needed here. Let's see here. It says attorneys may request to present oral arguments before the Supreme Court. Unlike the lower courts, there are no witnesses, juries, or testimonies. So pretty much the same thing. So they don't have to go through the whole shebang all over again. It's like, you made it to me, just tell me what you need and I'll see if this is what I'm going to do. So that's how that is. But again, all decisions are final. So with those final decisions. And I was looking over here. They do look at your written materials and briefs and things like that. So pretty much already gave you the brief earlier. But and I'm so sorry, I got somebody in my background. um, so pretty much already gave you the brief earlier, but yeah, that's just the gist of this. So, um, again, the Supreme Court is the final decision that's being made. So I'm just going to say, for this assignment's sake, that they too agreed with the decision of the Court of Appeals as far as the lower court. So again, um, it's sustained, I would say. So nothing else can be done beyond this point. He's exhausted everything he can possibly exhaust. She had a strong prima facie case. Based on the four elements, excuse me, of her case. I'm sorry, of her case. Again, she was correct. And it's unfortunate that that happened, and that also that her husband suffered as well. So, um, again, that's pretty much what we can say. The bulk of this is also it's all in chapter two, of the information that I found as far as my research. So it wasn't too much research, but just a little bit. The best source is the Tennessee Courts. .gov, so that shows you, and it gives you that timeline, and where you need to go. So anything that you're doing, like the marsupial courts, like it's kind of like traffic court or traffic tickets and things. You got juvenile and family, so that's you know what that is. Kids, mom and dad, family court. We have the criminal and circuit and business courts and chancery. So yeah, we've already discussed all of that. But yeah, that's why I said, if you, rule of thumb, if you don't know which one goes to the next, it's already here in order, so you know exactly where you're gonna go next. And that actually concludes part two. I just wanted to make sure I did not leave out anything here, because I did want to talk about a few things in chapter one. But chapter one is pretty much showing you, it's like terminology in the legal system, like federalism. It's a system of government in which people are regulated by both federal and state governments, which we already know that. So, because we already live it, so we already know. But it gives you, how to do your legal research, how to structure it, where to find your terminology, how to organize your writing, and that's the IRAC method that I gave you in the beginning, so you kind of know how that goes. And that's the IRAC method is pretty much just a brief. So if you've never done a case brief before, don't remember how to do a case brief, it's fairly easy. It's just bing bang boom, so you got it. Um, it talks about common law, precedent, stare decisis, if I'm saying that correctly, or it stands decided. Uh, and I would say that this is pretty much what that is. They agreed, hey, Wanda and Homer were correct. He was in direct violation. They saw the evidence, and what they needed to see. They gave him a second chance, and this was the third chance and final chance. And unfortunately, it stands decided. So there you go. And again, looks like I am done. So that's pretty much all I needed to say about that. I wanted to, but again, this is concluding chapter two, and I am Rashida Morris, and thank you again for allowing me to give you this information and go through this with you.